Hi and welcome back to our Freebie Friday video. Somebody wanted me to discuss what it really looks like to have to go to a court hearing. So I'll just go over this in general terms to give you an idea of what you could expect if you're in a court case. And typically this would be civil cases because those are the ones I'm most familiar with, and those are the most common for most people to be involved in. So let's say you're a party to the case, or maybe even a witness that has to go in to testify in court. I'll give you an overview of what the process looks like so that you can know what to expect. So when you have a court case, you'll get a notice of a hearing, or if you're one of the parties in the case, or if you're a witness that's not a party to the case, not part of the case, then you probably will get a subpoena. And a subpoena is just something that orders you to show up at a certain place and time so that you can give your testimony. So when you get there on a subpoena, sometimes you're going in on behalf of somebody that you do like, and sometimes you're going in on behalf of the opposite side, like the opposing side, which is somebody that you may not like, and so you might feel hostile towards them, so they'll call you a hostile witness. In that case, maybe even if you don't feel hostile towards them, but because you're not really for their side, the lawyer that's going to be questioning you, the one that subpoenaed you, is going to consider you a hostile witness in a sense, but both lawyers will end up questioning you anyway. So don't worry about it. It's very doable. So what happens when you go to court is, the first thing is when you show up, in most courthouses, you go through security, and they pass you through the little machine. That take your briefcase or your purse through the little machine. They could pat you down if you beep as you go through, and then you'll be able to go through, and then there'll be an information desk on that very first level. When you get to the information desk, you can ask them how to find the courtroom that you're looking for, or tell them what you're there for, and they'll guide you. Most of the courts these days, most of the courthouses have TV monitors, similar to the ones in the airports, that will show you the names of the parties, and then it will tell you the room where you should go, or the floor where you should go, so you end up in the right place eventually. But try to give yourself plenty of time for parking and for finding the courtroom itself. Once you get to the courtroom, depending on the type of court you're in, sometimes you're already in the right room with the judge that's going to hear that case. In some cases, some courthouses sort of do it on a rotation system. They call it a rotating docket. So they'll have a roll call, which is a general calling of the roll, like school. They see who is there and whether the cases are still moving forward that day, and ask the lawyers how much time they think they will need now that they're actually there. So you'll see different lawyers in the room and different parties in the room, and if you like, you can stay in the room or you stay outside. And then the lawyers would eventually come to get you. It's nice to stay in the room if you're one of the parties, so that everybody knows that you're there. So make sure you're there on time, and then once they call your name, you don't have to get up, unless, if you have a lawyer. But if you don't have a lawyer, then you do get up and let the judge know that you are present, and then tell the judge how much time you think you'll need to be able to say your part of the case. All right, so that's what happens first. And then once all of that is done, the judge that's doing the roll call would divvy up, divide up all the cases and pass them over to other judges in other rooms. So they might tell you, go to the second floor to Judge, Joe Brown, and go and have your hearing in front of him. So you'll go there, and then your hearing would start. And when your hearing starts, you'll notice that your lawyer is going to take you through all of this, by the way, if you have a lawyer. So if you're pro se, meaning that you're representing yourself, this video might be a little bit helpful to you, or a lot more helpful to you anyway. So when you get into the room where the court hearing is going to take place, there might be a few other people in the room that have cases in front of you or after yours. Okay, so you sit down in the general area. If there's a case already going on, or if there's a case ahead of you, the judge will tell you once you get there, or the judge's court coordinator will tell you. Once you find the spot where you are, if your case is called up, it will be called by the docket, by the case number, and it will be called by the party's name, typically. So you'll be able to tell that that's the case that you were there for. And then once it's called, normally the people that filed the lawsuit, which are the plaintiffs or the petitioners, that's what they're called, they tend to sit on the right-hand side. It doesn't mean that they're right. It's just that they're the ones that filed the lawsuit. So they tend to sit on the right-hand side. Some people do it differently. And then the people that are responding to the lawsuit, the defendants or the respondents, they sit on the left side typically. Okay, so you'll sit facing the judge, wherever you're supposed to sit. If you're a witness, that's not part of the case. Like I said before, you could be called to witness, to testify. Sometimes they ask you to sit outside until it's your turn to testify, so that the ongoing court proceeding does not taint your testimony in any way. Okay, it doesn't corrupt your testimony. So you might be sitting outside all that time and then you come in later. Sometimes they'll allow you to sit inside. So you'll be there and then the case will start. The plaintiff side is going to go first, and then the defendant's side will go next. So either the plaintiff or petitioner goes first, and then the defendants or respondents, depending on how the case is styled, they will go next. So the first side would put on their evidence and put on their witnesses, and then also at the very beginning, most of the time, they'll make an opening statement. Plaintiff or petitioner would go first by making an opening statement and then summarizing why they're there and what they would like from the court. And then once they finish the opening statement, the defendant side or respondent would also do an opening statement summarizing why they're there and what they would like for the court to do. And then once both sides have finished their opening statements, then the plaintiff will start putting on their case in chief, is what we call it. So the main part of their case. So that's evidence, witness testimonies. And then once they're done with all of that, they can rest their case, as we call it. So that means they will be done. But while the plaintiff side is putting on evidence, they can do that for a few minutes, or it could be an hour. It depends on how much time they ask for. And then once they're done with each witness, the defendant side, the respondent side, has the opportunity to question those witnesses as well. So when the plaintiff side, the party that's going first, is doing the questioning, we call it direct examination. And then when the other side is doing it, we call it a cross examination. So you hear those terms a lot. So that's what happens. And then once the plaintiff is all done, the defendant will then go next and put everybody on direct. And then the petitioner's side, the plaintiff side, now has a chance to do a cross examination. Now you can do a redirect as well. So let's say my client was on the stand and kind of messed up a little bit and was stuttering or stumbling over his words, and I need to clarify something for the court. I can do a redirect once I've already examined my client directly, and the other side, remember, the other side came and did a cross-examination and confused my client. I'll go back and say, I'd like to redirect. Or I don't have to say it, but I'll say, if the court says, well, would you have anything else? I say, yes, I do have a couple of things. So you'll notice that the plaintiff side will make an opening statement saying that this is why we're here. This is what we'd like the court to do. And we're going to put on this type of evidence. So that's called an opening statement. Now, the defendant's side will also get a chance to do its opening statement. Once those two sides have done their opening statements, then the plaintiff will go first to call witnesses and put on the evidence. Evidence could be video clips, it could be some documents, and things like that. It could be just witness testimonies. So they'll call somebody up typically and say, I have my first witness, and typically they'll call their client as the first witness, and then the client will start talking as the lawyer asks questions. And then once they finish with the witness, the defendant side, the respondent side, also has a chance to do what we call a cross-examination. So when the person's lawyer is the one asking questions to that person, it's called a direct examination, and then the other side can get a chance to do a cross-examination. If that cross-examination looks like it rattled the witness, you'll notice that that lawyer on the other side is going to try to do what we call a redirect. So they try to cover up or clarify some points to make their witness look better. And both sides get to do that, by the way. So that is possible. If you sort of mess up a little bit in your testimony, your lawyer would come back and try to redirect to clean it up a little bit, okay? So don't worry about it too much. So don't be stressed out. Always try to answer questions directly. And shorter answers are usually better than longer ones, because the longer ones can get you tangled up, and then people can use your words against you or use it to confuse the court. So you want to be precise, and you want to be brief, and you want to be truthful with your answers and very direct. So the example that I usually give is that when somebody asks you, well, do you know what time it is? Most people say, yes, it's 2 p.m. But really, that question did not ask you what time is it. It just said, do you know what time it is? So really, your answer should be yes. And then nothing else. And then if the next question is, well, what time is it? Then you'll say it's 2 p.m. So that's an example just to give you an idea how bad things get in court, how precise you really should be. But most people are not that precise, and they still do very well, as long as they're not incredibly hostile from the witness stand or condescending or rude. Then they don't come across as bad witnesses. And then, of course, if you're lying, typically the truth would come out anyway. So it's best to be honest if you're going to be on the witness stand. Now, if you're just a party that's not part of the case, but somebody that was called to testify, then that means you probably were called as a friendly witness to support your family member or employer or employee or somebody like that, coworker, or sometimes you've been subpoenaed by one of the lawyers because they want you there for a reason. So maybe you're a little bit irritated that they're bringing you into this case when you could be home or you could be at work, right? So you will be a little pissed off, but don't let it show too much on the stand. Just answer the questions as best as you can, and you can leave once your part of the testimony is done if you're not one of the parties to the case. So that is also a possibility. Just be there, be honest, and just do the best you can and be brief. And once you're being honest, actually it's easier to testify than when you're being dishonest. That's the truth. So that's my quick overview on that. Once both sides are done with the witnesses and the evidence, and typically with the evidence, the lawyer will come forward and hand you some documents or show you something on the screen and say, can you identify that? And you'll be able to say yes or no if that's the case. But usually it's something that they've already shown you before and you've seen, and they'll ask you if it's a true and correct copy. And that's just part of the process of admitting the evidence. And then the process will go on like that. But the important thing also is to take a pause anytime you're asked a question by the opposing side, because that gives your lawyer an opportunity to object if needed, to give you a cue not to answer the question. And then if the judge says you can answer it, then you can then answer the question. So that's something else to keep in mind. Once both sides are done, once the first side is done, the plaintiff side, they'll rest their case. So it's called resting your case. That middle part, they call it the case in chief, which is the main part of their case, is done. They'll rest their case, and then the second side will get to go and do the direct examination of any witnesses that they have, and then they'll also do the redirect if needed. So the other side, which is now the plaintiff side, will be able to cross-examine the witnesses of the defendant. So that's how the process works. And then once all of that is done, the defendant side would rest their case, and then they'll also both sides will be able to do a closing statement. The plaintiff side will do the closing statement, the defendant's side will do a closing statement. They typically take a couple minutes. This description that I'm giving you is for a bench trial. It's for a case where you don't have jurors, right? So you just have the lawyers and the judge. And then so the first side, which is the plaintiff side, will go ahead and do a closing statement, and then the other side will do the same thing. And then the judge would probably rule on the spot in a lot of cases if it's a simple enough case, or the judge might take the case under advisement. Advisement meaning that the judge is going to take it back, they're going to review it, take some time to do a little bit of research and talk to the staff attorney that's helping the judge, and then the judge will issue a ruling, final decision later on. It could be in a week, it could be in as little as 3 to 4 days, so sometimes 2 weeks, but that's when the case is quite complex. So those are bench trials as opposed to having a jury trial. And then if it's not a final hearing, so it's not a trial, not the big final hearing, you sometimes have motion hearings, maybe for a motion to compel, maybe for a motion to enforce, maybe for a restraining order or things like that. Those also are similarly styled, but the witnesses are not as many. and the evidence is not as big, and you don't have to make any like big closing statements or opening statements. You just go straight to the point and address the narrow subject of the motion. So that's still the same order of things. The plaintiff goes first and then the defendant. But if it's a motion, whoever files the motion is called the movant. That's the party that will go first, and then the other party would go second. And sometimes there are no witnesses at all, especially if it's a motion to compel, about if it's a discovery motion, things to do with lawyers fighting over documents that are supposed to be produced. There will be no witnesses in some of these hearings, and the lawyers will just go in front of the judge and do it themselves. So that's how that works. And so this is just a general overview for educational purposes only. Your lawyer will be able to prep you better, but I wanted to give you an idea of what it's like in court. Everybody gets nervous in court. It's not a big deal if you're nervous, but just make sure you keep your eye on the prize. Make sure you keep your mind on the goal that you're there for, and always tell the truth. The truth usually comes out anyway. So that's my overview on this. And if you have specific questions for your case, you will not be able to get answers from me on this channel, but you can contact my office directly. Thank you for watching, and I'll talk to you next time.